Final case this morning is People versus Terrance, Furline, and Alvin, Jenkins.
Good morning, Your Honors. May it please the Court. My name is Melissa Hoover, and I'm from the Saginaw County Prosecutor's Office, appearing on behalf of the plaintiff appellant in this matter. Your Honors, this Court granted this mini oral argument in order for both parties to answer one question: whether the Court of Appeals clearly erred in its application of the principles set forth in People v. Hannah to the defendant's motions for separate trials in this case. It is our position, Your Honors, that the answer to that question is yes. The best way to tackle the analysis set forth in People v. Hannah is to divide it up into a three-part analysis. We first begin with the affidavit or offer of proof that is submitted at the pretrial stage when the defense moves for separate trials. In this case, the Court of Appeals found, in contrast to the affidavit that was submitted in Hannah, that there were no specifics. In this case, the Court of Appeals found that there was specific information upon which the trial court could determine what the defenses ultimately would be. I respectfully disagree with that position. And the reason for that is because in this case, there was one piece of information that the affidavit contained in support of the motion for severance, and that was a statement made by co-defendant Jenkins to law enforcement, which was one of three statements with constantly evolving stories. But this particular statement, Terrance Furline alleged, was pitted them against each other, him and co-defendant Jenkins, because co-defendant Jenkins allegedly blamed Furline for setting the fire at the Home Depot. In People v. Hannah, this court noted that MCR 6.121C requires that in order to mandate severance, a defendant must provide a trial court with a supporting affidavit or offer of proof that clearly, affirmatively, or fully demonstrates that his substantial rights will be prejudiced, and that severance is the necessary means of rectifying that potential prejudice. The court also noted that without that proof, that the trial court's decision regarding severance would not be disturbed. So, the affidavit in this case presents the question: does this one fact about that one police interview, which was not intended to be played at trial, does that amount to the concrete, specific demonstration that substantial rights would be prejudiced? And I would submit to this court that the answer to that question is no. And thus, the affidavit was insufficient and conclusory, just as it was in Hannah, and did not rise to the standard that was required in order to mandate severance. Turning to the second part of the Hannah analysis, if this requisite showing was not made in the trial court, then we look to whether the requisite prejudice actually did in fact occur at the trial. And here, it did not. Neither defendant testified against each other. Neither of their statements were played for the jury. And actually, there was no defense that was put on, no defense witnesses. It was all, I think there was approximately 20 witnesses that were introduced by the people. So the requisite prejudice did not occur. However, the Court of Appeals, using the benefit of hindsight, found that there was prejudice through two witnesses. The first one being Doris Furline Walker, who was the mother of defendant Furline. Specifically, the testimony that was focused on by the Court of Appeals was that it was Jenkins' idea to start the fire and commit the retail fraud at the Home Depot stores, that it was his idea and that Furline was not involved. And that was the testimony that was focused on, which I would add that importantly, the majority of that testimony from Ms. Walker came from jury questions, responses to jury questions, and not necessarily through cross-examination or any questions by the prosecutor. And I think that that is also significant in terms of whether these defendants were pitted against each other through cross-examination of this particular witness. Also, the Court of Appeals looked to the testimony of Joy Royal, which I was a little confused about because Joy Royal was an employee at the Burton Lowe's store where Mr. Furline had returned. I think he had walked through the store and gotten a couple of faucets and returned those for a no receipt return to Ms. Royal. And this was on the day of the Saginaw Home Depot fire and not on the day of the Flint fire, which is the one that Ms. Furline Walker participated in. And I think that's significant because the connection that's drawn between Ms. Walker's testimony and Ms. Royal's testimony is really disconnected because we're talking about two different days here. And during Ms. Walker's testimony, she was presented with a receipt that was signed by her son, Terrance Furline, for the return of the saw that was taken on the 28th of October from the Flint store. So, in essence, Joy Royal's testimony was separate from this event that Ms. Walker participated in. In terms of whether Ms. Walker's testimony pitted the defendants against each other, I submit to this court that that is not the case here. She did offer testimony that theoretically went against both defendants and theoretically supported their ultimate defense that they were both mutually present. That being, Ms. Walker did not indicate that she saw who set the fire, and she essentially blamed the theft on herself, and also indicated that she had taken the saw into the Burton Home Depot store for a no receipt return. We know that didn't happen based on the record, but that was what she claimed at trial. So theoretically, her testimony supported both defenses, other than the fact that she had indicated that Mr. Jenkins had made some statements to her. That, in and of itself, did not equate to the mutually exclusive defenses that are referred to in Hannah as mandating severance. Finally, Your Honors, the third point in the Hannah analysis is, okay, so we're looking at the trial. Was there any sort of prejudice that occurred that would fit within the requisite prejudice? And if there was some sort of prejudice, was there anything that was less drastic than severance that was utilized by the court in order to prevent or at least lessen potential prejudice? And here, the Court of Appeals didn't mention that the trial court gave extensive instructions with regard to considering each defendant separately in light of the testimony and evidence presented. There was actually, and I believe it was the amicus that pointed this out, there was actually several.
But doesn't that make it kind of hard? I mean, basically, the jury's going to have to find somebody guilty.
I'm not really understanding your question, I'm sorry.
No, I understand. The question is that you're not leaving the jury a lot of places to go, right? Like, under your argument, it's very difficult in this circumstance, if you don't have severance for people to really make an intensive defense for themselves, right?
Well, the difficulty I have with that, Your Honor, is that when would joinder of trials then ever happen?
Okay, I got it.
Thank you. And so, Your Honors, under this three-part analysis, and I know that there's a lot more that was set forth in Hannah, but I was kind of trying to condense it down a little bit to get a grasp on what was going on here. But going through that analysis, that was not what was applied in this case. In fact, it would appear that the benefit of hindsight language was utilized essentially to look for prejudice, to relate back to the affidavit submitted to the court and the trial court's ultimate decision on the motion for severance. At this point, I would welcome any questions that you have.
You may reserve some time.
Thank you, Your Honors.
Good morning. So
Good morning.
Ronald Ambrose, I'm appearing on behalf of Terrance Furline. And the question that the court has ordered us to brief and argue in this case is whether or not the Court of Appeals clearly erred in its determination and its application of HANA. And in the Court of Appeals decision, court was quite specific and quite detailed on how HANA applied to the present case. HANA is basically, there are two separate cases in HANA, and one of the aspects of HANA, there is no separate trial, there's no separate jury. And the other avenue of HANA, there is a separate jury. And that was important for the Court of Appeals decision when they analyzed this case. We're talking about mutually exclusive and irreconcilable defenses. And the trial court in this case was well aware that there was a DVD, that Jenkins had made incriminating statements against my client, that Jenkins disavowed any involvement whatsoever with this case and pointed the finger completely at Furline. Once my client becomes aware of that, he submits a motion and an affidavit saying, I had nothing to do with this. I don't know what, why Mr. Jenkins is accusing me, and says that it was Mr. Jenkins' plan to create this arson, that he did create this arson, and created this retail fraud. I don't know how much more antagonistic or exclusive you can get.
Can you tell
And that's
me
that's why he filed the
Counsel,
motion.
can you tell me where in the affidavit Jenkins did completely disavow his role in the crimes? Is that a precisely accurate statement in your view?
My client says that he had no involvement in the arson or the retail fraud.
I mean, I understand how not having a role in the arson might communicate he didn't have a role in the arson, but the crime was broader than just the arson, wasn't it?
Well, I think they're all more or less interrelated. They're charging him with conspiracy in a criminal enterprise, and my client is saying, well, I wasn't part of any type of arson, I wasn't part of any type of retail fraud, and I think that's where...
Can you identify where he said all that? Can you identify where he said all that?
Yes, in the motion, which he verifies through his affidavit, it says, co-defendant Jenkins acted alone in setting the arson fire at the Home Depot and attempting to commit retail fraud by pushing a cart loaded with merchandise out of the store. So he says Jenkins acted alone. So, at a very bare bones minimum, and I think the Court of Appeals alludes to this, there should have been separate juries, at least. If judicial economy is one of the arguments that is being made by the prosecution, well, that's pretty much satisfied with separate juries. It's a common occurrence in cases, and it should have been appropriate in the present case. So, other than that, I don't have anything further.
Thank you, Counsel.
All right.
Good morning. May it please the court, Jonathan Simon on behalf of Mr. Jenkins. I know the court is well aware of the facts and has heard the arguments. Basically, I don't want to be redundant and repeat everything Mr. Ambrose has just said, but I will say that I think that in the case of Mr. Jenkins, the prejudice was exacerbated by the fact that Mr. Furline's mother testified as a prosecution witness to also blame Mr. Jenkins in an attempt to exculpate her son. And this was a witness called by the prosecution, named by the prosecution, known by the prosecution from the inception of the investigation. And it is clear that the prosecution knew, and everybody actually should have known, that Mrs. Furline Walker was going to point fingers at Mr. Jenkins. And so we'd have the prejudice here with Mr. Jenkins, which is significantly, I think, more extreme than even the prejudice to Mr. Furline, because we have the prosecution witness who is acting pretty much as a defense witness as well, but coming from the prosecution's case in chief. And while there was considerable amount of cross-examination and regarding by each counsel attempting to lay blame on opposing defendant and attempting to establish that their client was perhaps merely present, the testimony from Ms. Furline Walker, I think, placed the prejudice on Mr. Jenkins at a whole new level. And I think that it's clear under Hannah that there was prejudice, and that there should have been two juries, if not two trials. I believe that even though the naming of Ms. Furline Walker was not placed in the affidavit, the people knew that she was their witness. The parties knew. The court should have known, because there is a witness list which was filed. And therefore, to suggest that, well, we're going to remedy the situation by not bringing in the statement, I think is disingenuous. It would still, there would be prejudice even without Mr. Jenkins' statement, and clearly there still should have been two juries, notwithstanding any claim by the prosecution that the prejudice had been alleviated. If nothing else, calling Ms. Furline Walker as a witness created a greater sense of prejudice against Mr. Jenkins than even the fact that the attorneys were blaming each other's clients. I would ask the court to consider that, as well as the arguments of my learned colleague, and find that the Court of Appeals got it right and that there has been no abuse of discretion. Thank you. By the Court of Appeals.
Thank you, counsel.
Thank you.
Just briefly, Your Honors, just to address some of the points that counsel made. First of all, with regard to the mutually exclusive, irreconcilable defenses, even the Court of Appeals acknowledged in a different part of their opinion that both defendants claimed that they were merely present during this incident that occurred at the Saginaw Home Depot. And they didn't present any sort of evidence against each other per se, and obviously they acknowledged that they were on these video surveillance footages of these stores. So mere presence, although it would be unlikely that a jury would believe that both defendants were simply there at the time, it is possible that they could. And as such, their defenses in this regard were not antagonistic and not irreconcilable, because a jury would not necessarily have to believe one at the expense of the other. So I would disagree with that contention. Secondly, as far as the affidavit goes, Justice Markman is correct in the fact that Mr. Furline did not disavow all participation in the incident that occurred at the Saginaw Home Depot. He simply claims that he did not set the fire and that Jenkins was lying. And so it's still theoretically possible that he was involved in the retail frauds. And in fact, we have him on camera and his signature at, I think, 2 or 3 different home improvement stores where he completed these no receipt returns. And he was also seen on the surveillance camera in Saginaw near the aisle where the fire began. So he did not disclaim all involvement. Counsel also mentioned separate juries. And again, while I understand that perhaps that would I guess, lessen any potential for prejudice. I can't really say that under these specific circumstances that it would, because even if separate juries had been impaneled for these two defendants, the same exact evidence would have been admitted against both of them. So having dual juries, while it may have provided an extra safeguard, wouldn't necessarily have done much in this circumstance because all the same evidence would have been admitted. So they essentially would have been seeing the exact same things. So there was no real difference there that would have required separate juries. And there was no prejudice that wasn't sufficiently negated by the use of cautionary instructions by the trial court. And finally, with regard to Ms. Walker, cross-examination of Ms. Walker, I would disagree with the fact that it was extensive. I would disagree with the fact that it even remotely came close to using her to blame Jenkins or Furline for this incident. Instead, the majority of cross-examination was utilized to impeach Ms. Furline Walker. In particular, the fact that she essentially was promised to not be going to jail for this particular, well, for her involvement in this particular offense, that being the Flint incident. And defense counsel cross-examined her extensively regarding what promises were made to her and the fact that she didn't go to jail, she didn't face any charges, and she in fact held up her end of the bargain by testifying against these two defendants. Also, she was impeached extensively with statements she made at the preliminary exam, her drug use, her mental health issues. So I would also disagree with the fact that she was called simply to implicate Jenkins or Furline in this particular incident. Unless there are any questions, I would simply ask this court to reverse the decision of the Court of Appeals. Thank you.
Thank you, counsel. Case will be submitted. It is 11:25. We will come back at noon for our afternoon call.